up there, so I'll have to edit. Hello, and welcome to the first video on Watson TV. Thank you for visiting my channel. Before we get started, I want to remind you to click on the subscribe button so that you can have access to future videos. My name is Tyrone Watson, and I have been practicing law for about 10 years. What I have found is that the public is not very informed about some of the most basic aspects of law that we need often. It is always best to hire an attorney, but I understand that sometimes it is not possible. Here on Watson TV, I will be educating the public on the law and how it works so that you have the basic knowledge to help yourself in the event you are not able to afford an attorney. Every week, I will be posting videos that help you help yourself deal with your legal issues. My goal is to provide practical guides to specific legal issues that are likely to affect you. Because I am a Florida lawyer, most of what I post will be centered around the Florida law. These videos are simply tools that you can use along with other resources to help you approach your legal issues. Remember, it is always best to hire an attorney. There's a reason attorneys go to law school and practice for years. Having a skilled attorney is the best route because law can be very complicated and technical. As you know, American law is highly influenced by English law. However, American law developed in its own way due to the unique American experience. It should not be shocking that in the United States there are constant clashes in American politics because American jurisprudence developed in order to constantly clash. We call this checks and balances. Three unique features in American jurisprudence emerged in the United States. One, the benefit that common or non-constitutional law must be continually reflecting the currently held social attitudes. Two, the tradition of written constitution as the ultimate source of legal principles. And three, the delegation of lawmaking power to a constitutionalizing agent or government. You learned in high school that the United States received their independence from the United Kingdom because they were originally 13 British colonies and they became 13 states, all the way from what is today Maine down to what is Georgia. This pattern of English settlements in colonial America influenced how the law was applied. The original colonies attempted to basically transplant their English customs and practices here in the United States. That idea could have worked, but it would have to have been made to harmonize with the new government. For example, by the 17th century, the English bench and bar had become professionalized with structured patterns of education and achievements. America at the time did not have enough lawyers, clients, or source materials to replicate what the English had. This meant that high-level judgeships remained available to non-lawyers throughout the 18th century. In the state of Florida, in counties that has less than a certain population, non-lawyers can actually become judges. As a result, county courts became centers for trade and social intercourse in the colonies. The office of Justice of the Peace came to resemble that of an ombudsman, having varied informal powers of quasi-legal nature. During colonial times, there were few public reports of decisions. Law libraries were incomplete, English precedent was irregularly followed and given uneven weight. American jurisprudence really took a life of its own when the idea of a written constitution came about. With the idea of a written constitution, law was, in addition to the source of the law, it was a manifestation of current social attitudes, and it embodied the universal principles that were held by all. The very universality of those principles gave them permanence. Hence, law could not be changed completely with time, but law had to change in conformity with the mandates of the Constitution. A major purpose of a written constitution was to place permanent checks on governmental power. From its origins, American constitutions differed from the British model in rejecting the notion of absolute sovereignty in any branch of government. In this context of American constitutionalism, a theory of judicial interpretation first began to develop. Attempts to make laws synonymous with a written code invariably ran into problems of coverage. The language of constitutions or statutes cannot anticipate every contingency. There were debates on who should be the ultimate interpreter when there was ambiguity. Putting this power in an executive would essentially make them a monarch. Putting it in the legislature would essentially be giving the power back to the ones that made it ambiguous in the first place. The conflict was decided in a famous case you may have heard of called Marbury versus Madison. In Marbury versus Madison, it was determined that the Supreme Court of the United States would be that ultimate interpreter. So essentially, American jurisprudence, whether on the national, state, or local level, is a constant clash between the executive, legislative, and judicial branches. If you look at the PowerPoint that is associated with this video, episode 1 PowerPoint, you will see resources on the history of American jurisprudence. Now, ask yourself, what is the purpose of laws? Laws essentially solve issues in an organized and a systematic way. We think it makes more sense to sue your neighbor rather than set your neighbor's house on fire. When looking at laws, we put laws in 3 categories. Laws can be civil, criminal, or equitable. For simplicity purposes, I am going to define the areas based on their legal remedies. Civil laws deal with disputes between individuals. The remedy is usually damages, and that means money. You may have heard of punitive and compensatory damages. Compensatory damages compensate the victim for their injury, and punitive damages punishes the wrongdoer, kind of like a fine in criminal law. Criminal law, on the other hand, deals with disputes between individuals and the government. We call these crimes. In criminal cases, individuals can be incarcerated and fined. Equitable law is the third type of law. Equitable law applies usually when the civil and criminal law cannot be applied. Equitable law originated in the English courts. You may have heard of the Court of Chancery or the Exchequer. Examples of equitable law would be injunctions, declaratory judgments. Family law issues tend to be equitable. Now that we know the history of laws and the types, we need to look at the sources of laws. When dealing with the legal system, whether you are suing or being sued, it is important to thoroughly examine the facts and apply the law. In order to properly apply the law, it is important to know what laws govern your situation. Laws can be written or codified. We call codified laws statutory. Examples of written laws are the U.S. Constitution, the U.S. Code, your state constitution, and your state statutes. There are also judge-made laws, which we call common law. They are made from the U.S. and state court cases. There are also administrative laws that are followed by specific administrative agents, for example, IRS, federally, and your state Department of Motor Vehicles. Now, in Florida, there are trial courts. First of all, before I start, what I'm going to do is I'm going to direct you to, if you're in Florida, I'm going to direct you to a website that I find very helpful in seeing how Florida courts are set up. If you go to www.flcourts.org, you'll see how Florida is set up. And for those people that are not in Florida, I'm sure your state has something that explains the setup. In Florida, there are trial courts and appellate courts. Trial courts are courts that initially hear disputes. These are the courts where you see the lawyer presenting an argument with evidence, and in certain cases before a jury. You hear objections and all that type of stuff from the lawyer. That's the show that you see. Appellate courts are the courts that hear appeals. These are usually a panel of judges, and they hear the records from the trial. Now, in Florida, there are 67 counties, and each county has a county court. County courts are trial courts, and they hear misdemeanors, small claims up to and including $5,000, civil cases up to and including $15,000, and certified questions and traffic cases. In Florida, there are 20 circuit courts. Circuit courts hear felonies, family law matters, civil cases over $15,000, probate, guardianship, mental health, juvenile dependency, and delinquency, and appeals from county court cases. Florida has 5 district courts of appeals. These courts hear all matters not directly appealable to the Supreme Court and the final actions of state agencies. Finally, Florida has 1 Supreme Court. The Supreme Court hears constitutional questions, capital cases, bond validations, and public utility questions. The Supreme Court also hears express validity of statutes, construction of Florida or U.S. constitutions, decisions affecting the class of constitutional or statutory officers, and certified questions. I hope that you have enjoyed this video and have a better understanding of how the law is applied. Please follow my channel because I will be explaining practical applications of the law and how it will be useful to you. Because I practice in Florida, most of my videos are going to be specific to Florida. None of what I present is legal advice to any person. My video is simply a helpful resource. If you have a specific legal issue, you should consult an attorney. This is all for the first episode. Again, thank you for visiting my channel, and don't forget to hit the follow button. On the next episode, I will be discussing divorce law.